second set of slides and media law, and this is going to talk about libel, also known as defamation. And again, we're going to go over some of like the key points and the key cases, and you'll go into a lot more depth about the various defenses to libel in media law, but at least to get an idea of kind of what your requirements are as well as what your rights and protections are. So libel actually has a couple different parts to it. So libel is, according to Black's Law Dictionary, the damaging of a person's reputation by the publication or broadcast of false information. So all three parts that are highlighted in blue here have to be present to be libel. A person's reputation needs to be damaged, it needs to be published or made public, and then the information needs to be false. So if a person is someone who holds a public office or someone who's a public figure, we'll define that later slides. They also need to show that there's actual malice, that you knowingly disregarded the truth when you published this. So it's not just the you were duped into publishing something. You might be wondering why we're even talking about this. Is this really a problem? Is this something that you might actually run into? Or, is this a bunch of legalese that you're looking at for no good reason? Because I want to torture you. Well, actually, there's been a lot of research done about libel. And in fact, they found that it has what's called a chilling effect on the media, which means that the threat of libel suits will actually stop publication of true and in fact sometimes important material because of the fact that there is the chance that someone could claim libel, even if it is in fact truth. So the threat of a lawsuit is actually potentially worse than actually going to court because there's the chance you could lose even if you know that you're telling the truth. So studies consistently show that even the best newspapers, broadcast stations, and networks have lost major libel suits, and the amount that they've lost them for is so much money that that's why you need to run things by investigative journalism pieces by the lawyers before they go out. So basically, the threat of libel can potentially push media outlets into being less aggressive and can mean that they're overly cautious in how they report and how they edit pieces because even the idea that someone might come at them for it will stop them from having something be broadcast. Now, some critics argue that libel suits actually make journalists more careful in their reporting because they know how devastating the effects can be. So you can draw your own conclusions, but this is why we talk about it and why even at this early stage we want to discuss it. Now, you'll often hear defamation and libel. I've talked about it's the same thing. Defamation is kind of the key portion of libel. Defamation is the part of libel where someone's reputation is damaged. And in order to be libelous, the statement has to be defamatory. It can't just be a little bit mean. It has to actually call them into question and to damage them. The words must injure the reputation of a person or a corporation, and the words must subject a person to public hatred, contempt, or ridicule, or demean a person in his or her profession. So your book kind of calls out 4 areas where they kind of direct jurors to consider when you're considering whether or not something is defamatory. Have you accused someone of a crime? Does it damage them in their public office, profession, or occupation? So, for example, saying that someone has shaky hands might not be an issue, but if they're a neurosurgeon, it might damage them in their profession. Accusing someone of serious immorality, or accusing someone of having a, quote, loathsome disease, which I always love. Do they have a disease that either, again, if it's a disease that they could only get through immoral action, I don't know, they have syphilis, or it's a disease which is contagious. And again, your book points out this became an issue during the AIDS epidemic in the 80s, where accusing someone of having AIDS had serious implications in terms of people were discriminated against, they lost their jobs, so that kind of a thing. There are many defenses to libel. There's a giant chart in your book with the defenses to libel, and you will go through all of them when you take media law and ethics. But one of the key things to remember is that libelous information has to be false. You cannot defame someone with the truth. And you can't libel them if it's the truth. If a person's reputation is damaged by the truth, it is by definition not libel. So the truth is in fact a complete defense to libel. Now, there's two things to remember about this. One, the Supreme Court has ruled that the plaintiff, the one who is suing for damages, is responsible for proving that the information is false. As the defendant, you are not responsible for showing that the information you have is true. They're responsible for proving it is false. That's an important distinction. Also, you have to show what's called substantial truth. So you have to show that the essence of what you have broadcast or published is true. If there is a minor detail which is incorrect, but the substance of what you've posted is true, they can't basically get you on a technicality. Like, you know, if you've said that if you said that the mayor of a city had an affair with someone with red hair, and it turned out that they had an affair with someone with black hair, they can't say, well, you've defamed me. It's like, well, no, the issue is that you've had an affair, not the color of the person's hair that you had an affair with. So make sure that the substantial part of your argument is true. Privilege is another defense to libel. I didn't edit the top of the slide right. It's just privilege should be what that says. There's three kinds of privilege: absolute privilege, qualified privilege, and constitutional privilege. Most of the time you're going to be dealing with constitutional privilege, but absolute privilege is what people who are in office have when they are fulfilling the duties of their job. And in general, the press and the media does not enjoy absolute privilege. That is the privilege that, like, if you are a senator on the floor of the Senate, you cannot be sued for what you say on the Senate floor unless you are basically committing a crime. There are, of course, limits to this. In fact, your book mentions one of the cases that is kind of a limit to absolute privilege, having to do with Senator William Proxmire of Wisconsin, who started the Golden Fleece Award. So that's showing you the limits of absolute privilege. The next privilege is qualified privilege. Qualified privilege is a requirement that the information be an accurate rendition of the information. Not that it's 100% truthful. It's sometimes also called the fair and balanced requirement. Basically, that the report that you gave is accurate of what you were a witness to. So it's a bit of a fuzzy thing to kind of define and to try to understand. But basically that you are attempting to show an unbiased account of what happened. So you can report on, say, unofficial statements that happened in a court of law, and you can accurately depict what happened, and if what the people said wasn't true, you're covered because you reported what you witnessed. This is where qualified privilege is not the strongest defense, going to be honest. The one that comes up more often than not is constitutional privilege, and by constitutional privilege, they're referring to the First Amendment of the Constitution. That means that as the press, as the media, you have the right to report what on the facts that you have to hand, and this kind of goes back to the marketplace of ideas issue with the First Amendment, that the truth, the strongest idea, will rise to the top, that you are out there in order to try to deliver the truth as best you can. And it also in a way kind of comes back to that substantial truth aspect. And the idea that if you're reporting, and specifically constitutional privilege comes up a lot with mostly public officials. It's also kind of tied into the idea of the press being like a check on government. It does also come up with public figures as well, but the idea that what you're publishing, as long as you believe it to be true, and you are not publishing something with reckless disregard for the truth, or you're publishing something you know to be false, then you may have damaged a person's reputation and it may be false, but as long as you believed it to be true when you were publishing it, you're usually safe. So for the Supreme Court, basically, it kind of goes back to the reason for the First Amendment, that the press is there in order to try to help shed light on areas. And sometimes, especially when it comes to government officials, they're going to publish things that those government officials don't want to come to light. And if it is something that you have published to the best of your knowledge to be true, then you're safe. So think about, as a recent example, there was Dan Rather reported on some information that he had gotten about George W. Bush's time in service. Now, it turned out that the information he got wasn't accurate, but when he ran it on 60 Minutes, he believed it to be, and so did the network. Well, Dan Rather did lose his job, but the network did not get sued for libel because when they published it, they believed that it was true. The key case to remember in this is New York Times versus Sullivan, and that basically revolves around a full-page ad that was taken out that was trying to drum up support for Martin Luther King's defense. And basically someone said that he had been defamed because it talked about people in Alabama, and specifically like the police force. And, well, he was a member of that, so therefore he was defamed. And they basically said, well, you know, there wasn't any actual malice in it, and you weren't injured by it, so therefore you can't recover libel. In terms of public figures, Time Inc. versus Mary Alice Firestone is the key case, where again they're saying, well, there wasn't any actual malice involved, there was a falsity, something wasn't reported kind of as clearly as it could be, and because of that, yes, it wasn't true, but there wasn't any actual malice involved. They omitted a word, and so therefore you couldn't recover damages. In terms of public figures, there are two types of public figures. An all-purpose public figure is someone like Oprah, someone who has recognizable notoriety, someone who is in the public eye and may not be a politician, but is someone who has a lot of power and basically has access to the press on the regular, like a politician does. And then there are limited purpose public figures. Now, what's a limited purpose public figure? That person must be involved in an important public controversy. They must voluntarily step into the spotlight. If they are thrust into the spotlight by someone else, they are not a public figure. And they must attempt to resolve that public controversy or influence the public about the public controversy. Again, they must have access to the press, basically. If you are someone who has no ability to influence people, then you cannot be a public figure. So if you're someone who is an ordinary person and you don't have access to the press yourself, then you don't need to prove actual malice, because basically you don't get a chance to rebut. Someone who is a government official, someone who is a public figure, well, they have the opportunity, they have the power to have their say in the marketplace of ideas as well. If you're an ordinary person, then you just have to show negligence, not actual malice. So basically, did you do your due diligence as a reporter and attempt to make sure and verify your facts? Have you gone and gotten this from two different sources to make sure that these are actually the case, that this is actually the case? And so if you haven't done that due diligence, then you could be found negligent if it's an ordinary person, and then you could in fact be sued for libel. And just one last point to mention, because companies can be sued for libel as well. There have been some cases that involve the internet, and specifically internet service providers, but this also applies to like any place like something like Twitter where they host things. If the company only acts as a provider of information, and this, the CompuServe case is the big case that kind of is the defining jurisprudence in this case. If you are just providing access, so like something like where Twitter, where they weren't moderating anything at the beginning and they were just posting anything that anyone put out there, then you cannot be held liable for what's posted on your servers. If, on the other hand, you moderate in any way what is coming out, so this is the Prodigy case, or if there's an AOL case, which I'm not sure if your book doesn't mention, I don't think, but we mention it in Media Law and Ethics. If you create the content in any way, then if someone, so in this case, it was, I think Dan Savage saying something for AOL, since he was acting on behalf of AOL, or in the case of Prodigy, if they moderate the content and someone says something libelous, then they can be held liable. So just being careful about if the company is at all, if it in any way kind of basically is acting as a gatekeeper, then they can be held liable. So basically, it kind of boils down to the idea that if you are reporting something fully, you're reporting both sides of the story. If you report things factually, and you report things in good faith, you're usually safe. But to just be very careful, excuse me, of the facts as you report them, to make sure that you're reporting them truthfully so that you don't get sued for libel. In the next section, we're going to talk about privacy, and I'm going to get some water in between.